the court administration has told us, and I think this is probably correct, that as if we do trials virtually, we have open courts here in Texas, and in order to allow people to see what the judges are doing, we put things on YouTube. We put our cases on YouTube so that the public can see it, just like they would be in an open court here at the courthouse. So let me kind of tell you what we're going to do now, which is closing arguments. The way this works in Texas is that the plaintiff will get to go first. I've given each side a total of 15 minutes. He's going to have 10 minutes. The defendant will have 15 minutes, and then the plaintiff will have an opportunity for a brief rebuttal. We'll go ahead and get started. Are you ready, Mr. Maldonado?
Ready, Your Honor.
All right. I'm going to go ahead and spotlight you for everyone, and you may proceed.
Thank you, Your Honor. Please, court counsel. Good morning, ladies and gentlemen. First, I just want to take this opportunity to thank you. This process has been a little different for everyone involved, and I just want to thank you for bearing with us and for being patient with us during the few difficulties that we did have during the process yesterday. Obviously, this whole process wouldn't be possible without people like you willing to sacrifice your time to help us different parties settle disputes. So on behalf of myself and Mr. Escobar, thank you. Now, yesterday you heard some testimony and saw some evidence about an accident that occurred on June 3rd of 2017. You heard my client, Mr. Escobar, testify that he was driving on his way home from work. He'd just gotten off, so the accident happened a little after 10 p.m. You heard that he was on his way to try to get some food and was traveling down Peterson. You heard him testify that as he was approaching a driveway for an apartment complex, that a vehicle being driven by the defendant pulled out of the apartment complex and hit the front passenger side of his vehicle. You heard the client, Mr. Escobar, testify that on his road on Peterson, there wasn't like a stop sign or anything like that, that he had the right of way in this situation. You heard Mr. Escobar testify that the force of the impact pushed his vehicle from the right lane that he was traveling in, kind of over a little bit into the other opposite lane of travel. And the force of the impact pushed his body to the left and caused his elbow to hit his door or window. You heard Mr. Escobar testify that immediately after the accident, he felt some pain in his elbow, but he also said that he was kind of in a state of shock. And so he just thought that the elbow pain would go away on its own and didn't really think anything of it. You heard him testify that this was the first motor vehicle collision he had been in, so he called his dad because he didn't really know what to do. His dad came to the scene, called the police. The police arrived and he spoke with them and then ultimately left the scene, and his father took his vehicle to his father's house because Mr. Escobar didn't know if his vehicle would be able to make it all the way back to his house. You heard Mr. Escobar testify that over the next couple of days, he started developing the pain in his neck and then also in his mid-back or lower back area. And you heard him testify that he was hoping that the pain would go away on its own, but ultimately when it didn't, that's when he sought out medical treatment at the Celebrity Healthcare Chiropractic Clinic. You heard Mr. Escobar testify about the different things that they did for him at the chiropractor's office, how on the initial visit they spoke with him, got an overview of his symptoms, did some range of motion testing to see like how far he can bend his neck and the different pain that the movements caused him. And then they prescribed a treatment plan for him. And then you heard Mr. Escobar testify about the different treatments that they gave him at the chiropractor's office. You also heard Mr. Escobar testify that while he was treating with the chiropractor, that they had another doctor, Dr. Orieno, who's a medical doctor, come and examine Mr. Escobar and then ultimately prescribe him some medication to help him with his injuries. You heard Mr. Escobar testify that also while he was treating for his injuries, he was still working, but was put on some work restrictions or some light duty because he wasn't able to bend over and he was unable to pick up heavy objects or heavy boxes that he was required to at work. You also heard Mr. Escobar testify that he was unable to work out during this time like he had before the accident. And fortunately for Mr. Escobar, his job was accommodating of him and his restrictions, and they just kind of shifted him to the front of the store so that he wouldn't have to bend over a lot or have to lift any heavy items that could have aggravated his injuries. You also heard Mr. Escobar testify that he treated for about a month and a half, and that by the end of his treatment, his pain had completely subsided and his injuries were healed by the treatment he received at the chiropractor's office. And we feel we have shown by a preponderance of the evidence that more likely than not standard, that the accident and all of the injuries suffered by Mr. Escobar were caused by one thing and one thing only, and that's the negligence of the defendant. And because of that, when you go over the jury charge, I'm going to ask that you answer the questions a certain way. And am I able to share my screen, Your Honor?
Let me enable that. There you go.
Thank you. And so for the first question, whose negligence, if any of those listed below, do you find proximately caused the collision made basis of this suit? I'm going to ask that you answer yes for Ms. Ansar, the defendant, and no for Mr. Escobar. Again, you heard my client's testimony about how the accident occurred and how it's clear that he had the right of way in this situation. He was just driving down the street, and the defendant just pulled out of the apartment complex right next to him and hit the front passenger side of his vehicle with the front of her vehicle. And because I'm asking you to answer only yes for the defendant, you don't have to answer question number 2, because it's clear that 100% of the accident was caused by the defendant. For question number 3, what sum of money, if paid now in cash, do you find would fairly and reasonably compensate Hector Escobar for the injuries, if any, that resulted from the occurrence in question? I'm going to start with question number 3, the medical care expenses incurred in the past. You heard Mr. Escobar testify about the different treatment that he received from the chiropractor and from Dr. Horiano. And you'll be able to go through the medical records on the iPad, I believe, that has them all uploaded, and you'll be able to see the different injuries that he was diagnosed with, along with the treatment that was prescribed for them and the cost associated with that treatment. And I represent to you that the total cost of his chiropractic care and the visits with Dr. Horiano is $5,987. So I'm going to ask that you award that for question number 3, medical care expenses incurred in the past. For question number 1, physical pain and mental anguish sustained in the past. You heard Mr. Escobar testify about the pain he suffered after the accident. First, immediately after the accident, you heard him testify he had pain in his left arm or his elbow area. And then over the next couple of days after the shock wore off from the accident, he testified he felt pain in his neck area, and then also in his mid back and lower back area. And he said that this pain lasted for a little over a month when he was treating with the chiropractor. And so for the physical pain and mental anguish sustained in the past, I'm going to ask that you award $5,000. For part 2, or question number 2, physical impairment in the past. You heard Mr. Escobar testify about the things that he couldn't do or they're more difficult for him to do after the accident while he was still treating with the chiropractor. You heard him testify that he wasn't able to work out like he could before the accident. You heard him testify that it was difficult for him to bend over and that he was unable to lift up heavy objects and boxes and things he would need to do at work. And so for that physical impairment in the past, I'm going to ask that you award $5,000. And again, ladies and gentlemen, I'm asking you to award these to help compensate Mr. Escobar for the injuries that he suffered as a result of this accident. And when the defense or Mr. Archibald comes and talks to you, he's going to, explain the kind of different version that we heard from the defendant of how the accident occurred. And at the very beginning of the trial, I asked that you be patient, hear both sides, and then make that determination, applying our burden of proof by preponderance of the evidence, that more likely than not standard, how you think the accident occurred. You heard a completely different version of how the accident occurred from the defendant. She said that she had already pulled out of the apartment complex driveway and was driving straight on Peterson Road. Then you heard her testify that almost immediately before the impact occurred, she saw Mr. Escobar's vehicle in her lane of travel for some reason that she couldn't explain. And that, again, for some reason, he just turned left in front of her vehicle and caused her to hit him. Again, apply that more likely than not standard to it. And which version do you think is more likely true than not true? Do you think it's more likely true than not true that for some reason my client was traveling in the wrong lane of travel and going the wrong way on the road, and then instead of just going back into the right lane of the road, he turned left in front of the defendant's vehicle?
1 minute.
Accident. Or do you think it's more likely true than not true that the accident happened the way my client described, that he was driving by this roadway, He feels like the defendant didn't see his vehicle, so she pulled out of the driveway and hit the front of his vehicle, the front passenger side of his vehicle with her vehicle. You get to make that determination. But I feel like we have proven by a preponderance of the evidence that the accident and all of the injuries suffered by Mr. Escobar were caused by one thing and one thing only, and that's the negligence of the defendant. Thank you, ladies and gentlemen.
Okay, you need to stop sharing. There we go. All right, Mr. Archibald, you have 15 minutes.
Thank you, Your Honor. May it please the court, counsel. Ladies and gentlemen of the jury, we're here. We've made it to the end of the road. As you can tell, we haven't been able to agree on a whole bunch of stuff so far, right? So obviously you've heard that there are two different versions of how things played out, but you have one burden to hold the plaintiffs to. They filed the lawsuit. They sued my client for this car accident. They have the burden of proof, right? And we talked about the burden of proof all the way back in voir dire. And each and every one of you promised that you'd be able to hold the plaintiff to their burden. And we also talked about the 3 C's of this lawsuit: conduct, causation, and credibility. So I want to start first with conduct. The negligence that the plaintiff has the burden of proving is focused on my client's conduct, right? So we've discussed different examples of accidents that are just accidents, right? I believe we even had an example in voir dire where someone suggested that if one or both of the drivers don't see the other person, the other car, then, that might not be negligence. And ladies and gentlemen, that's exactly what we have here today, right? So plaintiff's counsel pointed out, and rightfully so, that there are different versions of different facts, but there is one glaring consistency. Neither one of these people saw the other car before it was too late. Neither one of them could have avoided this accident because they didn't see the other person. So let's focus specifically on my client's conduct leading up to the accident. Ms. Ansar testified that she came to a stop when she was pulling out of that apartment complex parking lot. She looked both ways. She didn't see any other cars. She pulled out slowly. She didn't gun it. She didn't accelerate quickly. She pulled out like she always does, like she has for the last 12 years that she's been driving in that area. And then at that point, that's when she saw the plaintiff's vehicle. And even then, she did her best to try to avoid it. She didn't know what was going on because by the time she recognized it, she said that there's nothing she could have done. She slowed as much as she could. She thinks she was at a stop. She's not sure. She was trying to stop. She didn't do anything but act ordinarily careful. Nothing that she did, none of her conduct was out of the ordinary. And that matches the definition of negligence, right? Your Honor, do I have screen sharing privileges?
You should. Let me see.
Okay.
Yeah.
So the definition of negligence specifically is, oh my goodness, given to you by the court and the court's charge. And it reads,
I don't know what's going on there.
I don't know what's going on either. Bear with me. I appreciate everybody's patience.
Let me see. You know what? I could probably do this for you if you want.
I got it. Here we are.
Okay.
Negligence means the failure to use ordinary care. My client did everything ordinarily. She came to a stop. She looked both ways. She didn't see anything. She didn't do anything out of the ordinary. And causation, moving to the next fact.
Mr. Archibald, are you frozen? Are you okay?
think he might be frozen, Your Honor.
either car. So they did not foresee that event. And moving further into causation, it's that conduct specifically that has to cause this accident. And ladies and gentlemen, we've heard several examples as to how not seeing somebody is not negligence. And I have
Mr. Archibald, are you there? Am I
Hello?
frozen or is he?
I can't hear him either, Your Honor.
He's frozen.
I can hear you guys.
Okay. Yeah, it's frozen for me too. I can't get the,
Here, I can see you guys now. Can you hear me?
We
I can hear you.
you. It's just your screen. Your screen is frozen,
Maybe,
so we don't see you moving.
maybe
Well,
turn
that's
off
okay.
screen share.
I can keep
try,
rolling.
I can.
As long as you can hear me, I'll just wait for it to think its way out. So
I've never seen this happen. I don't know what to do. I hit stop participant sharing and it's not working.
can you guys hear me?
Yeah, go ahead.
Okay. We've already talked about how my client's conduct did not cause this accident. She did everything within ordinary reason, within ordinary care. Now let's talk about the injuries itself. He testified that his car was pushed to the left and he hit his elbow on something inside of the vehicle. He doesn't know what, but he thinks he hit his elbow on something. But yet when the police came to the scene, he didn't request an ambulance. He didn't say that he was injured. The police didn't request an ambulance for him. But here we are dealing with a purported injury. If you don't believe it, don't compensate for it. So even further, the plaintiff testified yesterday that he only injured his neck, some region of his middle lower back, one specific point in his back, and his left elbow. Now, that's problematic because the medical records and plaintiff's counsel didn't use them in his closing argument, but I've got them here for you just in case you might not have an opportunity to look at them. I wanted to pull up a few pages as well, but I don't know if my computer will be able to share them right now because it's still spinning.
Mr. Archibald, why don't we do this? Can you hear me okay?
Yes, Your Honor.
Why don't you leave the meeting because you've frozen? I've never seen this before on Zoom. I've spent probably close to 1,000 hours on Zoom. I've never seen this. You've frozen, I think, everybody's screen. I think if you come back, maybe we could, because I can't even stop your sharing for some reason. I don't know why.
I can't either. Yeah, when I hover over stop share, it's just got that pinwheel.
Why don't you exit the meeting and come back in, and hopefully that will clear this up. Let's see. There we go. All right.
Okay.
And I just want to make clear, I mean, there's going to be tech issues here. Please, don't decide this case based on somebody having tech issues. So once Archibald is back, oops, did you let him in? Mr. Archibald, are you there?
Looks like he's trying to join.
Did you let him in, Julian? Okay, let's see.
There he is.
Is that better?
All right, there you go. Okay. Did everyone see him okay? All right, Mr. Archibald, you have about 8 minutes left.
Perfect. Thank you, Your Honor. Okay, so we were talking about causation for the injuries specifically. My client's negligence has to cause these injuries, right? And we've already established that my client did not do anything negligent. She didn't do anything but act ordinarily careful. She was already established in her lane, and then the accident happened. right? So any injury that is claimed cannot stem from my client's negligence because there is no underlying negligence. And even further than that, the charge specifically reads, and in abundance of caution, I don't want to freeze everybody's screen again, so I'm not going to try to share it. The question 3 says,
I can share a screen for you if you want to, if you just tell me what you're looking for.
I was going to go to the portion of the charge that's talking about the injuries, if any.
Let's see. I don't know why it's, let me see. Oops. There we go. Okay. Tell me what you're looking for.
Question 3, Your Honor.
Is that it?
Yes, Your Honor.
Okay.
So right there after it says, after Hector Escobar for the injuries, if any, if you don't believe that he's injured, then he's not injured, because it all comes back to credibility, the third and most important of the 3 C's. Credibility, the believability of the evidence. And we've discussed all day yesterday, it seems, that the evidence is what comes from the witness stand. The testimony that you heard from both my client, Ms. Ansar, and the plaintiff, and the documents that they're producing for the medical records, the documents that they want you to look at. And the credibility of all of that together has to meet plaintiff's burden, and or plaintiff meets their burden through that evidence, and they have not met that burden. And I'll go through a couple examples as to why. So first, we've got to talk about the witness credibility. So Mr. Escobar testified that he was driving along the street and didn't see my client at all until the actual impact happened. At no point before the impact, at no point before the 2 vehicles touched, did he see my client's vehicle. A Lexus, an SUV, a larger vehicle than his own. He didn't see that until they had already struck. We also know that he's got a couple of examples of shortcuts that he takes. The shortcut to Burger King. We've got examples of how he doesn't necessarily adhere to any of the restrictions or the guidelines that his doctors or managers give him. We heard him testify that, even though his manager gave him work restrictions for light duty, he was still sneaking around and climbing up ladders, even though his manager didn't want him to, and picking up boxes, whether heavy or light, regardless. He was still sneaking around trying to take care of things that he was restricted in doing. And also we've heard testimony from Mr. Escobar himself saying that not only in this treatment, but his treatment for an unrelated issue, he has a pattern of not following the doctor's guidelines in sticking to a specific treatment plan. He's testified yesterday that he, in 3 different medical issues, our accident that we're here about today, and 2 other things that came about later on in his life, that he stopped treating sooner. So those are credibility issues. Is he going to adhere to what his doctors are telling him to do? No, which is a great segue into the next point, and the credibility of the records themselves. And Mr. Escobar wasn't very certain as to whether or not he had x-rays. But after I refreshed his memory with his deposition testimony, it was clear that he did not receive any x-rays. He testified that he did not receive x-rays in this treatment. Yet we have $914 just for x-rays. He was charged for a procedure he did not receive. He testified under oath that he did not receive any x-rays, yet he incurred charges for those x-rays that he claims he did not receive. And if he didn't receive them, if he testified he didn't receive them, you can't make my client pay for them. And that's what he's asking you to do. He's asking you to tell my client to pay for this treatment he did not receive. And on the notion of treatment he did not receive, he testified that he did not injure his shoulder, either shoulder. And in the chiropractor bills, if you look at each individual line and you match up all of the charges with the dates and treatment, and I'm going to try one more time to share my screen, Your Honor.
Okay.
So fingers crossed, everybody, that you don't freeze, and I'm not making a funny face if we do. But in the medical records, in the chiropractor bills, the majority of the bills, there are lines and lines and dates of treatment that he claims to a body part that he claims he did not injure. And are you guys, is that coming through?
Yes.
Now it is.
Okay. So this highlighted portion right here is manual therapy, 1+ region per unit. That's relating to his shoulder. The medical records match up and they show that this is the treatment that he received to a shoulder that he did not injure in this accident. And he was charged once, twice, 3, 4, 5, a total of 10 times, $69 each time for treatment for a body part that was not injured in this accident. And these medical records, these chiropractor records also include charges for the x-rays that he did not receive. And we've also heard him testify that he stopped treating, or his pain had gone away entirely about a week before he concluded treatment on his own, despite having a concrete, definitive, tangible treatment plan. He testified that he stopped treating a week before his last, the pain went away a week before his last visit. And in that last week, he incurred almost $2,000 in bills, over $1,000 in bills. So when you add all of that up, that's over $2,000 in charges for treatment that he did not need because his body part that they were treating was not injured, or his pain had completely subsided and it was absolutely gone. His testimony confirms that.
Mr. Archibald, I'm sorry. One of the jurors dropped off and she added her back on.
Okay.
Give me a second. Miss Bowie, can you hear me okay?
Yes, I'm back. I don't know, when he screen shared there, it just kicked me out.
Okay.
My screen
All right.
froze up and then come back.
Mr. Archibald, if you want to go ahead and just kind of repeat the last few seconds, that she was only off for a second.
Okay. I don't remember. Okay. So he's got over $2,000 in charges for treatment that he either, one, did not receive, or two, was treating a body part that he did not injure in this accident. And with Dr. Horlano's records, I don't want to risk kicking anybody out, so I won't show you, but on the one of the 2 pages, the very first page, Dr. Horlano's records indicate that he was examining his right shoulder.
Could you spell that for the court reporter, Horlano?
Horilleno. Dr. Horlano, I guess. Excuse me. He was examining his right shoulder, but Mr. Escobar testified he did not injure either shoulder in this accident. And Dr. Horlano charged $574 for a detailed office visit, yet he wasn't even examining the right body part. Even if there was something related to a shoulder, he had the wrong shoulder, but Mr. Escobar testified he injured neither shoulder. So $2,500 already on treatment that isn't related to this accident. That's half of the bills right there. And we haven't even talked about the specifics of each individual charge. And I don't want to waste your precious time because
you have 1 minute.
And I only have 1 minute. And at the end of the day, Miss Ansar has been nothing but consistent. She didn't know exactly how plaintiff's vehicle was oriented or exactly which direction or how swiftly it moved one way or the other. But she was consistent in the fact that she didn't see him before. She checked before she started her turn. She was established in her lane, and she didn't have her phone. She didn't have anything to eat or drink in the car. She wasn't changing the radio. She had no distractions. She did not have any conduct that was out of the ordinary. And none of that conduct can support a finding of negligence. So the only answer you can find for my client on question 1 is no, she was not negligent. And the causation doesn't even come into play, because if there's no negligence, there's no causation. There's no causation of the accident. There's no causation of the injuries. And that's all based on the credibility of each witness, the credibility of the records, and the credibility of plaintiff's case in general. There are so many inconsistencies on one side of the field, and my client has been nothing but consistent and done nothing but act ordinarily careful. Thank you.
Okay, just want to go over a few points with you, ladies and gentlemen. First, again, you heard my client's version of how the accident happened, and you get to be the judge if that's more likely true than not true. And I believe that it is. And in my client's version of how the accident happened, this wasn't a situation where accidents just happen. The defendant was in a driveway, and as my client's passing her, she just pulls out, even though she doesn't have the right of way, and she failed to maintain a proper lookout. She wasn't paying attention to if it was safe for her to enter the roadway. That's one of the first things you're supposed to do, is make sure it's clear whenever you're pulling out, and make sure the roadway is clear so you don't have an accident. Just because she didn't see him doesn't mean that it's just an accident that just happened. Like, by not seeing and not making sure that the roadway was clear before she entered it, that is negligence. That's failure to yield the right of way, failure to maintain a proper lookout. That's the definition of negligence. And then defense counsel, when he was going through his client's version, it's not quite how she explained it. He said that she had just pulled out of the apartment complex, and then about that same time is when the accident happened. But if you remember when she testified yesterday, she said she had already pulled out of the apartment complex. She was already driving down Peterson. She said she had been traveling down Peterson for about 1.5 to 2 minutes. So it wasn't a situation where she had just turned out and then my client came up and that's when the accident occurred. She said she had already been established in her lane for 1 to 2 minutes, and then my client was, for some reason, in her lane of travel, and then for some reason turned left in front of her vehicle. And again, you get to determine if that version is more likely true than not true. But quite honestly, that just doesn't make a lot of sense to me. Why my client would first be in her lane of travel, and then instead of just going back into the correct lane of travel to avoid the accident, he for some reason would turn left in front of her vehicle. But my client's version, I believe, is more likely true than not true. And he was driving down the roadway. He had the right of way, and he didn't see her vehicle because she wasn't on the road yet. She was in this driveway, and he saw her when she pulled out in front of him and hit the front driver's side of his vehicle. In that version, she was negligent by not maintaining a proper lookout and for failing to yield the right of way to him because he was already established on the main roadway. So I think it's clear that she was negligent in causing this accident. Secondly, defense counsel pointed out that my client didn't request an ambulance when the police arrived at the scene. And he explained that he felt some pain in his elbow, but he thought it wasn't a big deal. It would go away on its own. And he also said that he was kind of in a state of shock, so he wasn't feeling any pain in any other parts of his body. But you heard him testify over the next couple of days, that's when he felt the pain in his neck and his mid back or lower back, and also in his left arm or elbow area. And I think it's pretty clear that all of those injuries were caused by the accident, because you heard Mr. Escobar testify that he didn't have any pain in his neck or back or left arm at any point before the accident. It was only after the accident because it clearly caused those injuries. And defense counsel also said that Mr. Escobar was sneaking around at work and doing things that he wasn't allowed to do. Like, I don't know that he ever testified he climbed up ladders, but he said that he used stairs, and he also said that he would still lift some boxes, and he said it was a box of like vials or syringes that weighed less than 5 pounds. That wasn't what he was restricted from doing. He was restricted from bending over and picking up heavy boxes and unloading trucks like he had done before the accident occurred. And he said he wasn't doing that, so he wasn't violating his work restrictions or sneaking around and doing things he wasn't supposed to do.
1 minute.
Thank you, Your Honor. And in this case, he did follow his doctor's orders. He said that he was treating with them, did everything they told him to do, and then after about a month, the pain was kind of gone, but he still treated because his doctors told him that was the treatment plan for about another week. And then he ended his treatment and all of his pain was gone because the treatment was successful in helping his injuries. And again, we feel we have proven by preponderance of the evidence that the accident and all of the injuries suffered by my client were caused by one thing and one thing only, and that's the negligence of the defendant. And we ask that you return a verdict in favor of him. Thank you, ladies and gentlemen.
Okay. Let me go ahead and talk to you guys. We're at the end of the trial and we're about to start deliberations. First off, I need to give you some final instructions about your jury deliberations. Some of you have served on juries before, so in theory, it's going to be very similar to what you've done before. But I want to highlight a couple of things that I think are extremely important for this type of trial and a remote trial. First off, it's extremely important that all 12, when you're deliberating, that all 12 of you are in the jury room, the virtual jury room, when you're deliberating. If somebody drops off or has to take a break or whatever, don't continue to deliberate while they're gone. Wait for them to come back. If there's an issue, if there's some connectivity issue and you need to get any assistance, we have IT here. If someone isn't able to talk because of their connectivity, make sure you reach out to us. We'll have IT come in and help you. But I just want to make it clear that you cannot deliberate unless all 12 of you are in the room together. You've been a little group of 13. You probably haven't got a chance to know each other very well yet. Now you're going to be a group of 12. Miss Wynn, you're going to be excused from jury service. Miss Wynn, as soon as we excuse her, she is no longer a member of the jury. And so you have a little world here, the 12 of you. She's no longer part of your world. And so you can't talk to her. Don't try to call her on the phone or message her or anything like that during your deliberations, just like you wouldn't message anyone else. You can't, she's going to be a part of the public as soon as she's released, and you won't be able to speak to her at all until the jury, you're released as a juror, and then you can call her or tell her whatever you'd like. But as long as you're deliberating, you're not allowed to do that. There's going to be some tech challenges in doing this. We're going to try to overcome them. I hope that the Adobe sign process works. If it doesn't, let us know and we can figure out a workaround for it. But we're going to try to get you, once you get a verdict, I want to remind you that if it's unanimous, then only the presiding juror signs the verdict, and we'll send you one form. If it's 10 jurors, and we send you a different form, or if it's 11 jurors, we send you a different form. So once you figure out you have a verdict, and that means that you have 10, 11, or 12 jurors agree on all, we just lost somebody. Who did we lose? Nope, we didn't, sorry. Once you have a verdict with either 10, 11, or 12 of you agreeing, you'll need to reach out to Rhonda and Mr. Rowland, and she will go ahead and send you the correct form on Adobe Sign. If for some reason this doesn't work and you try and it's not able to work, and then we can do this orally. I'd prefer to do it in writing, but we can do it orally if we have to. And so, but just do your best to try to get a signed version of it. Does anyone have any questions before I send you to the jury room? Oh, and one last important thing. I had Mr. Rowland, because he has a scanner, he is not necessarily the presiding juror. You guys get to select your own presiding juror. I just had him receive those documents because he has a scanner and he can print them out. So, but if you guys get to choose whichever presiding jury you'd like, if it's Mr. Rowland or somebody else, it's totally your choice. Okay, any other questions? And if you have any issues whatsoever, you call Rhonda, and Rhonda will get in touch with me and we'll bring you back onto the Zoom call, okay?
Miss Nguyen has a question, Judge.
Miss Nguyen?
Yeah, I thank you. I'll be dismissed, but the iPad, when are they going to come back and pick it up? And
so
also,
that's a great question, Miss Nguyen, and the marshal's office is going to reach out to you about coming and picking it up. Please, I don't think anyone here would do this, but they do have fail safes. This is the these iPads are owned by the Office of Court Administration, and so if we don't get them back in a reasonable amount of time, they will start making a really loud, annoying noise. So we don't want that to happen, and so just try to cooperate with the Marshal's office in getting the iPads back once you're finished with them. All right, and Ms. Wynn, you're going to stay here. We're not going to release you to the jury room. Any other questions? Okay, I'm going to go ahead and send you to the jury room. Oh, sorry. Okay, you should be getting an invitation in just about 30 seconds. Okay. Good luck, guys. I think all the jurors have gone to the jury room. So, Miss Wynn, I need to give you your final instructions. I believe everyone's gone. Does anyone see any jurors here?
No, Your Honor.
They're gone. They're
They're
all.
all gone. Okay, they're all gone. Perfect. Miss Wynn, I need to give you your final instructions. You are now a member of the general public. You can speak to whoever you like about this case. The attorneys may want to talk to you about this. They may contact you today. They may contact you in the future. You can talk to them if you'd like. If you feel comfortable, we'd love to hear. This is obviously a pilot program that we've never done before. And so there were a few tech issues, but if there's any suggestions you have that on how this could go any more smoothly, we'd love to hear from a juror's perspective if you're okay with that.
I do. Just like, thank you very much for my opportunity to serve. Just like yesterday before we ended, I prefer if we have a map or a direction to when the the attorney show, we can see clear the direction and the way and how the accident, or also a picture of the car at the scene at the accident. That will help the juror a lot when they look at that. That's all, only for me, for my opinion.
I agree with you 100%. I'm not sure why but I'm sure there was a reason the attorneys didn't do that, but I can understand completely what you're saying. That probably would have made this a little bit clearer. And there is the technology to do that. We could have done it, but did you have anything about the process of the case? I know that we had a couple delays and things like that, but anything else that we could have done that you feel like would have made your experience better? Did you feel okay about the experience?
The first time for a virtual, this is happened everywhere, even at work. We will have some technical issue, but so far after we go on, it's smooth, except for some, something that we cannot control is when we get the frozen. It depends on the internet, and that has happened anywhere. And once in a while, hopefully in the future, the technology getting better, we don't have that issue.
Yeah, we had a couple of issues, but I agree with you. There's not much you can do about it, but I appreciate it, Ms. Wynn. Did the attorneys or anybody else have any questions for Ms. Wynn? If you're okay with answering them, it's totally up to you.
Yeah, Miss Wynn, obviously we're all trying something new in the format and everything, but is there anything, thinking that I don't know, I'm trying to get in the mindset of having this be the reality moving forward. Is there anything that we could do stylistically that would make it more efficient for you as far as the technology? Maybe I noticed
besides making the maps she talked about was
right. Yeah. So I noticed that you were one of, I think, 2 people in the entire 50 person panel that had a virtual background. Is there anything like that you would suggest that we could use to bolster our appearance or anything like that?
I don't know if you can do virtual background for everyone, or, that will help them to concentrate more on, looking at, someone background and something else. So, but I don't know, it's up to, each individual, but I don't know, the judge have the option to give a formal background to everyone. That I don't know, sorry.
Right.
Yeah,
But I
if
think
the
that
judge
might help.
does say that. Okay, our IT person gave a suggestion. We'll talk about that later. So I don't know that I can make the jurors have virtual backgrounds. If you can do that, I don't know how to do that. So I'll have to look into that. But
That's what I don't know either.
yeah, I've never seen that before, where you can control someone else's virtual background. But,
yeah, I don't think so. Yeah.
All right. Well, thank you so much, Ms. Wynn. Mr. Maldonado, did you have any questions?
No, Your Honor.
All right, Ms. Wynn, thank you so much for your service here today. You're going to be now excused. Just make sure you work with the marshal's office to get the iPads returned, and you'll get we have your name and information, so we'll be sending you'll be getting a check from Dallas County for your service. And thank you so much, and we really appreciate your service.
Thank you very much, and I wish everyone have a good day today.
All right, thank you.
Thank you so much.
Bye-bye.